Hi, Ted. Thank you so much for being here.
My pleasure.
All right, tell us, um, at what point did you come into the transaction? Was the transaction already negotiated by the time
Oh,
you
yeah.
were brought in?
Yeah, I think my first substantive involvement in the matter was briefing and arguing the standing motion, which ended up not exactly being pivotal,
Mm-hmm.
but it was a very interesting issue. Um, it turned on the fact that Omnicare, at least until relatively late in the process, was not a stockholder of NCS. And even though Delaware, for reasons that are shrouded in the mists of time, has allowed bidders
Right.
to bring fiduciary duty claims against targets, which is, I suppose, necessary, but hard to comprehend.
I don't make the sense of that either.
Yeah, okay. Didn't, we thought we had a shot at getting Omnicare knocked out of the case completely,
Mm-hmm.
but it never really worked completely. Plus, there was always the stockholder plaintiffs anyway, so I don't think the case would have been litigated differently had we won or lost the question.
Well, let me ask you something. What was your first reaction when you saw the complaint and
Yeah.
decided to think about your strategy for how you'd approach it?
When I first heard about the matter, and the facts were fully baked,
Mm-hmm.
I remember thinking, well, this is a pretty tough case. This is about as locked up as a deal can ever be. I was puzzled by the fact that there was going to be an annual meeting at all. I didn't understand why there was going to be an annual meeting with a preordained result. Then I learned that apparently Alcott and Shaw, they didn't have the power to act by written consent. And therefore there had to be a meeting, or maybe it was some SEC rule that required there to be
Must
a
have been
meeting.
SEC rule because I checked the certificate because I thought the same thing. They must have eliminated the power to act by written consent, but they didn't
Oh, that's
in the
interesting.
certificate. So it had to have been some other
Okay.
regulatory
And
body.
You know, it was a case from our point of view, from Genesis' point of view, in which NCS was a failing company. It was insolvent, it was in bankruptcy.
Mhm.
They were looking at a future in which the equity was going to get nothing, and the bondholders, the debt holders weren't even going to get, they were going to be made to sacrifice as well.
Right.
So our client viewed themselves as having sort of rescued this company and provided at least some payment to the equity holders, which every penny of which was a windfall
Mm-hmm.
compared to
Sure
where
was.
they had been. So in return for that, we had an unusually, locked up, lock, stock, and barrel deal, which precluded any competition, any further competition, and made the vote kind of a silliness.
A foregone conclusion.
Yes.
Well, but the truth is there had been a lot of history and a lot of history with Omnicare and Genesis, which would support the fact that Genesis would say, I need some tough terms. I'm not going to be a stalking horse.
Right, I do remember learning afterwards, not in real time, that a lot of this was driven by the prior experience between Genesis and Omnicare in bidding for another company. And that's often, things like that I think are often lost sight of when you go back and look at these facts. I mean, CEOs and boards of directors are real live human beings, and if they've had experiences where they think they got the short end of the stick, driven by somebody else previously, they're going to try very hard not to be made a fool of again. And I think, no doubt, that drove a lot of the deal terms in this situation.
And I don't disagree that that should have been the case. And because they didn't seem to play ethically on the care when you go back and look at their behavior. But whether it was ethically or not, and that's up for debate, is that the fact that the best they were going to offer was something to sail out of bankruptcy court. Right. And, your client was saving the company in many ways.
Right, and the price we wanted to extract for that was maximum deal certainty. And, this was, Omnicare this case was decided at a time where 2003, I suspect that the last statement from the Delaware Supreme Court prior to that was probably either or both of Time Warner and QVC.
Mm-hmm.
And that was informing a lot of the way people on the buy side and the defensive measures side of these cases were viewing the world. There had never been a case. I think Omnicare was actually the first case that made it clear that defensive measures in a sale were going to be viewed with enhanced scrutiny under Unical.
Correct.
And that they were going to be separated out. And we made an argument that under Time Warner, that was inconsistent with Time Warner. Time Warner sort of glommed everything together. When Time Warner held that a stock-for-stock merger was a pure business decision, it sort of gave the back of the hand to the dry-up fees and whatever the other defensive measures were here. In this case, the defensive measures sort of got pulled out, partly because they were structurally different. They were in a separate agreement. But they were pulled out and put under a separate microscope. And that, from a litigator's point of view, that made it harder to defend.
I'll bet. And that ties in with a question I've always had, is why they needed to have the company a party to the voting agreements in the first instance, but we'll need some of the strategic persons involved with the negotiations to find out what the thinking was
They know.
behind that.
Sometimes the litigators don't see the sausage getting made.
No, you really don't. You're stuck with whatever's handed to you, right? But so your opinion was, or your initial reaction was, we're doing a good thing. We're representing a company that's going in there and doing a good thing and making a reasonable offer with terms that make sense in the context. And what's the problem?
You had an independent board,
Mm-hmm.
clearly fully informed and acting deliberately.
Mm-hmm.
No conflicting interests. More than that, you had Alcott and Shaw with not just the majority of the voting power under a dual class structure, which wasn't really focused on that much in the case, that their voting power came not from their, but they were the largest single economic owners of the company. And they had no reason to sell for anything but the best price they could get.
No.
And they took our deal. And they took our deal, accepted our exclusivity demands, and they didn't think it was necessary to risk that in order to see what Omnicare might or might not be willing to do, particularly in the way that Omnicare had first come to them with, I don't remember what it was called in the case, it was called low ball or no ball or something.
It was
but
selling the asset out of bankruptcy court.
They're doing an
Nobody
asset
would-
sale where the debt wasn't even going to get fully
No.
paid and equity would have gotten zipped.
No.
So to that degree, we would thought, we were on the side of the angels insofar as we were being attacked by stockholders were concerned.
So were you surprised?
Surprised that there was a challenge? No. There was always a challenge. But Omnicare, which was to some degree a Johnny-come-lately with a higher price, what our position was, okay, what was done wrong here?
Mm-hmm.
Where was the violation? We didn't see one. And the way we tried to frame the issue was, unless Delaware is going to say that the highest price has to always win, even if nothing that preceded it can be really shown to have been a breach of duty, then we didn't see how we could be stopped.
No.
And that's why the decision in the Supreme Court, the decision in the Court of Chancery was sort of, mainline, Delaware, intense scrutiny, heavy record, but intense scrutiny of everything that the board did. There was a full discovery record of everything that happened. There were no mysteries, no surprises, and I thought a really remarkable decision from the Court of Chancery. I wasn't surprised that they appealed because, why not? They had one thing going for them on the appeal.
What did you think that was?
Higher price on the table.
Yeah, but that came after the fact.
Understood. But, cynical people have often said that there's really only two rules in Delaware. in takeover cases. Rule number one, you never get an injunction if you don't have a higher price. And number two, you always get an injunction if you have a higher price. Of course, the exception that proves the rule is Time Warner, arguably.
Mm-hmm.
But we thought that was, besides lawless, kind of a terrible policy idea. But we turned out to be wrong. I mean, I was, as we chatted before, my principal involvement was in the charter issue, which
We'll get to that.
which has
in a
been
minute.
buried under
Mm-hmm.
under a lot of time, and that's probably where it should stay. But on the fiduciary issue, in a stock for stock deal, to lose on the ground that the defensive measures violated Unical, that was news to us. And I must say, the first time I read this opinion, and I read it again because I thought maybe I was misremembering it. The statement in the majority opinion that the latitude a board will have in either maintaining or using defensive devices adopted to protect a merger will vary according to the degree of benefit or detriment to the stockholders' interests that is presented by the value or terms of the subsequent competing transaction.
Mm-hmm.
When I read that for the first time, I went back and read it again. And I didn't understand it.
Because why is the board being judged by something
Yeah,
that comes
it
after
said
the fact?
basically, I mean, I understood the idea, which is, this case is often cited for, that directors' duties are unremitting.
Mm-hmm, mm-hmm.
That's all fine. But the directors of NCS, and yeah, we weren't being charitable. We made them make a decision,
Right.
and they made it. And they were held to have breached their fiduciary duties, not because of anything. If the clock had stopped
They would have
at
been
that
fined.
point in time, there'd be no claim at all.
Right.
The claim that what they did turned out to be a breach of fiduciary duty not because of anything they did, knew, or could possibly have foreseen, but because Omnicare later decided to throw more money on the table. That was news to us.
Well,
And the shocking thing about this, well, shocking is a big word. Surprising thing about this opinion is, this is the first opinion I know of, and maybe to this day, that sort of says Delaware is saying there are certain things that are just not in the director's toolbox. You just can't do it. You just can't sign a merger agreement without a fiduciary out in which the vote is preordained by voting agreements.
under any circumstances.
Full stop.
Mm-hmm.
And of course, that was the point of the dissents. And back in 2003, dissents in corporate law cases were
Rare.
really almost unheard of.
That was making a big statement when you had two.
And one by the
Justices
chief. It was a big deal. Didn't help us at all, but it was nice to read.
No, did it trouble you at all that you didn't get a written decision from the court until 4 months after the order?
Well, did it trouble us?
Well, the die was cast, but were
Look,
you
we knew we
surprised
lost,
it
and we
took-
had I forgot exactly what was in the order at the time, but we had some idea of why we had lost. I mean, we knew we had lost because the deal was completely locked up.
Mhm.
But I couldn't, for the life of me, figure out how they were gonna state that in a doctrinally coherent way. I mean, what were they gonna find? I mean, they weren't gonna reverse, and they did not reverse.
They accepted, in fact,
But
all
the-
the findings of
correct,
the
Correct,
Court of Chancery.
right. And yet found that it was a new idea. It was just a new idea. Right, wrong, or indifferent, it was clearly new to say there are certain things directors can't do, even if they acting pure of heart, on a fully informed basis without any conflict, in a transaction designed to get the greatest value for the equity. You just can't do certain things. Okay?
I look at that and say, that really is something that would preclude some people from wanting to be first at the table. Because no matter what they do, and no matter how well they negotiate, somebody after the fact can come in, and the board's responsible to have to
Well,
Talk
you
to
raise an interesting question. I don't know whether people think of it from the interloper's point of view. How comfortable would you be if you were in Omnicare's shoes in the next case, saying, "Well, I can just wait. I don't have to participate," because they had every opportunity
Yeah.
to participate.
They sure did.
I can just sit back, be cute, make all kind of demands about due diligence and things like that that make my offer unattractive. Smoke out. What bid am I going to get from my competitor?
Right.
Let them lock it up any which way they want, and then I'll just put a higher bid on the table and win. I don't think people thought that way necessarily afterwards. And don't forget, there was, as you know, a firestorm of statements, including statements from members of the court that this is going to be a highly confined case. And then there were a couple of CLE programs. People use words like life of a fruit fly.
Well, that was the dissent. Did the majority, and I can't recall, ever say that it was
No.
based on the confines of the
No.
facts at issue? So therefore, why wouldn't you take the position of Omnicare next time around? I think I might roll that die.
Okay, I hear you. Well, that's the beauty of the common law, right? One case at a time.
That's exactly right. And it just seems as if when you're looking at the review of the defensive measures, the history of both NCS and Genesis with Omnicare, you would have thought would have helped carry the day.
Yeah.
But can we shift for one moment and go back to that charter issue, because it's interesting. Our former vice chancellor, he thought, frankly, that was the most intellectually challenging issue. He enjoyed that issue.
It was a fascinating issue.
Mm-hmm.
I don't have it front of mind, but it involved what I love the most, which is careful reading of charter language and trying to figure out how they apply in situations that probably you don't have any real basis to say or anybody had thought of at the time the thing happened. But the notion that by signing the voting agreement, Alcott and Shaw should have gone from high vote to low vote never made any sense to me. But there was traction to the other side. It wasn't like they had nothing to say. It wasn't a silly argument. It was a swing for the fences argument. It got.
Remember the in connection with proxy?
Oh, yeah.
And you're like, I remember my first reaction being, I don't follow that.
But you wonder sometimes why people raise certain arguments in cases.
Mm-hmm.
Was one of the purposes of Omnicare in raising that argument to sort of put greater pressure on the fiduciary point?
Why not?
I mean, were they saying, look, if you're not going to rule for us on the fiduciary point, you can still get the stockholders a better deal by just making a narrow decision based on this charter provision? Who knows?
No, but you're right about that.
Could
I
be.
agree.
It could be.
I'd love to go back and ask the vice chancellor how that influenced him, if it did.
Yep.
And I will give a simpler option. Thank you. Now that's interesting. And frankly, a lot of that discussion as well, where they talked about transfer, you can read agreements all the time that don't properly define transfer for
Absolutely.
purposes of the agreements at issue.
Yeah.
And limited partnership agreements and LLC agreements, they really fail to.
Yeah,
Often.
words are messy things, but we don't
Words
have a lot of
are very
alternatives.
messy. Yes, that's correct. All right, anything else you want to say about the charter issue, how about the standing issue? You had said,
The standing
anything
issue
more?
was an interesting one. I enjoyed that a lot also, even though nobody ever really thought it was going to, change the course of the litigation. But, we had argued, I say we, I mean my firm had argued,
Mhm.
I think it was in Revlon, perhaps for the first time, or right around the time of Revlon, which would have been 84, 85, that bidders shouldn't be allowed to raise fiduciary issues. And we had a kind of a very tight doctrinal kind of argument.
Mhm.
Fiduciary duty issues should only be raised by people who are on the same page as the Sedicate trusts or whatever the English
Right.
words or something. The people who are the beneficiaries of the fiduciary duty. Well, the bidder is the exact opposite. The bidder is the buyer. The buyer is a direct conflict with the seller.
Mm-hmm.
Why should the bidder be able to litigate fiduciary issues that are designed to benefit the selling stockholders? It didn't make a lot of sense to us. We never won that issue, and the way Delaware sort of, and not just Delaware, but other states have done the same thing, have sort of elided the issue, is to say, well, the bidder at least has to have the fig leaf of owning shares in the company
At the time.
of the conduct complained of.
Right.
Now, what the contemporaneous ownership rule, of course, it comes out of the derivative law context. Now, once you talk about the derivative law context, you have to ask the question, well, is the plaintiff an adequate representative? Well, how in the world is a bidder an adequate representative for the selling stockholders? Well, but I think it was really almost like a rule of necessity.
Mm-hmm.
Hard to imagine all the cases that ran from '84 until today, frankly.
Mm-hmm.
Suppose Delaware would have gone the other way. Suppose Delaware would have said, you know what? Bidders don't have standing to assert fiduciary claims against targets and their directors. Wow, we would live in, that would be a true alternative universe. There would still be the stockholder plaintiffs,
Mm-hmm.
but the stockholder plaintiffs, more so then than now, didn't have the resources to litigate these kind of cases. These were knockout, drag-out cases. The good thing about them, of course, is they were pre-email. None of these cases could be litigated today. It would be impossible.
Why do you say that?
Oh, because the crunch of, there aren't enough human beings or contract lawyers on this planet to review the emails that would have had to been collected and reviewed to litigate cases like Revlon, Unical, Newmont, Time Warner, QVC, on anything like the expedited timeframes which were required to be litigated for those cases to be decided. I do not know what would happen if there was a preliminary injunction practice in a hostile takeover case,
Right.
in which somebody needed to have a preliminary injunction hearing in, what was the time in those cases, between 20 and 60 days?
Correct.
You couldn't do it. You simply couldn't do it. And I don't care how many lawyers you threw at it. I don't care how much money you spent on vendors. You could not possibly gather, review, produce that number of emails. And even if you said, okay, all rules are off, this is expedited case, just produce everything. Produce their inboxes.
You can't do that.
First of all, you can't do that, but not only that, you can't review it. It's just not possible on either side of the case. So email's done. The best thing email has done is it waited long enough to come along until we had a firm grounding of Delaware takeover doctrine. Otherwise, we never would have had one. And I truly believe that.
Well, do you have a position today about emails? Do you
Sure.
And what is your position?
7 words to save America. Delaware should adopt a statute. An email is not a document. I don't have a co-sponsor for that legislation yet,
No.
but I'd be happy to have one.
Well, we'll take it under consideration at the council. See if we can get that, because I agree with you, and I think people don't put the level of care in emails that they would in a
And they
written
never
document.
will. They never will. Because emails the reason they're not documents is they're really spoken words caught on a page.
But how about a text message?
Worse. And nobody, look, we ourselves, right? Everyone thinks they're funny on emails. They think they're hilarious in text. To say nothing of ephemeral messages like Snapchat, and now there's WhatsApp and also direct tweets
Oh, I don't know.
are a new subject of discovery. So this is a never-ending miasma, if that's a word.
Well, and I suppose those others would say that those unmeasured responses are showing you what the real intent was. But then again, agreements always say you're doing it based on the terms written herein and nothing else.
I would agree that candid emails often reveal truth,
Mm-hmm.
but they reveal truth only about the speaker, and their influence in an overall construction of a narrative is the prejudicial effect of their influence outweighs their usefulness. If you have an email that supports a certain narrative, it could be from a third level person
Right.
talking to somebody else who's not a decision maker, but that can stink up a case
Mm-hmm.
and affect a court's view of a board level decision.
Mm-hmm.
That's very hard to get rid of. So I don't know what the real answer is, other than my statute, which ain't going
Email
anywhere.
is not a document.
It may
Okay.
be 6
Email
words.
plus
Well,
everything
well,
else.
I'll
Yeah.
define the word
Text.
email.
Yeah, we'll have to get it really
Yeah,
broad.
yeah.
But I understand that challenge. And going back to the dissent, when you knew that 2 justices, including the Chief Justice, dissented, that really sends a mixed message to the public. And like you said, would you have been Omnicare and after the fact try that same set of circumstances again? How did it temper your advice to clients, if at all, after this decision?
Well, that's a very good question because, the word got out right away once we had these opinions, and then you had comments in CLE programs of people saying, Omnicare will have the life of a fruit fly, it'll never happen again. I get calls from either my corporate partners or other people saying, well, we want to do this transaction and we want to do A, B, and C. And it was exactly like Omnicare. And I said, well, that's Omnicare. Can't do that. I said, what do you mean you can't do that? That decision
Look at the dissent.
Yeah, that decision's not right. I said, well, it may not be right, but if you're going to have to litigate this in the first instance in the Delaware Court of Chancery, what's the Delaware Court of Chancery supposed to say? That the majority opinion is not the law of Delaware?
Can't.
And you look for ways around it. People look for things like acting by written consent. And there was a bench ruling that said, yeah, that's different. That's pretty hard to understand, particularly if there was a contract obligating the person to act by written consent shortly afterwards.
It's form over substance.
Hard to understand. But at the end of the day, the one change is everybody now, I don't think I've seen a merger agreement since Omnicare that doesn't have a fiduciary out, not just for right to change a recommendation, but you can't couple it with a forced to vote under 251. I don't know that that's a bad thing. I think that what it's actually done is I think it's put a lot of the pressure on the post-signing period. People have gotten more aggressive than they might otherwise have gotten in doing one-off transactions, that is with a soft market canvas or maybe even no market canvas, if they have a fiduciary out coupled with either a go shop period or some period of time in which it's free for other bidders to emerge.
Right.
And I fully understand the contrary argument, which was any deal that's subject to a stockholder vote that's not locked up is a fiduciary out, whether it's in the agreement or not, because all someone has to do is come along and make a higher bid and you're just not going to get the vote.
Exactly.
But look, the world didn't fall apart because of Omnicare. The deal market certainly didn't dry up. Will we know how many deals didn't get done because of Omnicare? No, we'll never know. If you ask me to guess, do I think it's a lot? No, I think it's probably none. But what was rattling about the opinion, and still rereading it today is rattling about the opinion, is sort of the point that Chief Justice Steele, subsequent Chief Justice Steele, hammered home in his concurring dissent, which was you've announced here a prescriptive rule.
Right.
There's something you simply can't do no matter what the circumstance, no matter what the context. And that was very un-Delawarean. And that's what made this opinion surprising, to some degree unnerving. And you just sort of wondered, when you get an opinion like this, that it's obviously very hard to predict how a court's going to view a set of facts. But this court viewed the set of facts the same way the Court of Chancery viewed the set of facts. It adopted the findings of the Court of Chancery.
Which was very, yes, you're right.
And yet, announced a rule that certain things you just can't do. Well, that was startling. And it made people wonder for a while, well, what else are we going to find out we just can't do? But, you know, in the great common law tradition, things sort of got righted, and the sky didn't fall, the world didn't end, and corporate lawyers just structured around a lot of this, and litigators found clever ways to win cases no matter what.
So let me ask you something. There was a point in time where, notwithstanding the no-shop clause, that Genesis permitted NCS to speak with Omnicare. Do you have any sense of why that was done? Or again, that was before your time?
It's before my time, but I would suspect, and you can confirm this with the transactional lawyers, I may be completely wrong.
Mm-hmm.
I suspect the reason is probably a fear that if they, you know, even when you have a right,
Mm-hmm.
you also know that asserting it
Yes.
might not look great in a litigation. And sometimes you might feel like, and I don't know that that's the case here, but there are other situations I've been involved in that are like this, where people say, well, why should we let this happen? We have the right not to let it happen. And you say, well, yes, you have the right not to let it happen. And you know, we think you're right, and you have a perfectly legitimate basis not to let it happen. But think about how it's going to play in a courtroom. And if you let the person talk and they got nothing to say, that's a whole lot better as a record than not letting them talk. I don't know that's what happened here, but there are many situations in which that's how situations play out. One example is don't ask, don't waive, which people put into agreements all the time, no matter how many times the courts say they don't like them, or maybe they're even per se no good, people are going to put them in. And then the question comes, okay, once you sign the merger agreement, even if the don't ask, don't waive don't fall by their own terms, shouldn't you release those people from the don't ask, don't waive? It's a very similar kind of dynamic. Clients will say, well, why do I have to do that? Can you tell me it's definitely illegal? No, it's not definitely illegal. Nothing's definitely illegal. But people don't like them. A lot of judges don't like them. You're going to at least get a disclosure claim about them. Why don't you disclose this? Things like that. They say, well, we'll deal with that if it happens. Okay. You know, there's still a lot of judgments you have to make even after the case, even after facts look like they're fully baked. They're not off and out of the oven yet.
Yeah, and I find that the part most troubling is the idea that, yes, okay, even if you say you always have to have a fiduciary out, everything was being analyzed by activity that took place after the merger agreement was entered into, and I just don't know how it's just not a good way to do business.
You could chalk it up to hard cases make hard law.
Mm-hmm.
That's what I think happened here. Very tough for a court. When a court knows that by signing an order, stockholders will get more money, that's a huge amount of pressure. Huge amount of pressure. I'm not so cynical as to say a higher bid will always flush away everything that came before it. But if I was a judge and someone saying, look, the stockholder's going to get 50% or 30% or 20% more value if you sign this order striking down these defenses.
Yeah.
Not an easy call.
No, not an easy call at all, but what do they say? A deal should be a deal. One would think.
No argument here.
So speaking of the deal, you were supposed to get $6 million breakup fee, your client. You got 25. Kudos to you, but do you have any idea what the dynamics were there?
I have a glimmer of a memory on that. The glimmer of a memory on that is Omnicare very much didn't want to have any further litigation. And I don't remember exactly what the hook was, but there was we had a prospect of asserting some kind of a claim if this wasn't resolved quickly.
Mm-hmm.
And they wanted it resolved quickly.
All right.
And I can't put the pieces together in my head, but speed had a lot to do with it.
And they were willing to pay the 25.
Yes.
And query whether the 25 really is enough compensation for time, aggravation, legal
Certainly
fees,
not.
all that.
Almost certainly not.
It seems like a drop in the bucket.
Yeah, also,
to
I mean,
me
the
compared.
reason, one of the reasons people get fees like this is when they've gone out into the marketplace and done a transaction that they don't close, they've exposed their business strategy to the world.
Yes.
And you can't reasonably determine the cost of that, but it ain't nothing. It's something. And that's one of the reasons people insist on high breakup fees. Because once we tell the world this is the direction in which we plan to go, and we're thwarted from doing it, you run the risk of being positioned as a damaged company. And that's part of the reason for that level of compensation.
Thank you so much, Ted. This was a great help, and I'll follow up with your transaction
Great.
partner.
Always great to be in Wilmington. Thank you.
You're welcome.